Sir, stop right there. Don't take another step.
I live here, I'm going home.
We got to call suspicious individual. That's you. ID, now.
The officer's voice cut through the echoing lobby before the glass door had fully closed behind him. Sir, stop right there. Do not take another step. The words bounced off concrete walls and polished tile sharp and rehearsed the kind of tone designed to establish control instantly. The man froze mid-motion, one hand still gripping a small ring of keys, the other resting against the doorframe he had just unlocked. It was 6:42 p.m. early evening in a mixed-use federal building downtown. Outside traffic hummed and a bus hissed to a stop at the corner. Inside, fluorescent lights buzzed faintly above a nearly empty lobby that smelled of cleaning solution and old paper. Security cameras blinked red in the corners, silently recording every movement. The man turned slowly. He was black mid-40s, dressed plainly in a dark coat and pressed slacks, the kind of clothing that did not draw attention unless someone was already looking for a reason. "Is there a problem, officer?" he asked, his voice calm, even measured by habit rather than fear. The officer stepped closer, hand hovering near his duty belt. "I need to know what you're doing in this building." The man glanced back at the door behind him, then down at the keys still dangling between his fingers. "I'm going home." "I live here." The officer's eyes narrowed, scanning him from head to toe. "That doesn't match what I was told. We got a call about a suspicious individual entering the building." He nodded toward the door. "That would be you." A brief silence followed. Somewhere deeper in the building, an elevator chimed. The man inhaled slowly. "I unlocked the door with my key. I've done nothing illegal. Am I being detained, or am I free to go?" The question landed hard. The officer's jaw tightened. "Don't get smart with me. I asked you a question." The man did not raise his voice. He did not step back. He simply stood there, shoulders squared, eyes steady. "I answered it. I live here." A second security camera caught the officer shifting his stance, planting his feet wider. The tone changed. "You got some ID on you." The man hesitated for half a second, not out of confusion but calculation. Then he nodded. "Yes. But I'd like to know the legal basis for this stop." The officer scoffed softly. "We can do this the easy way or the hard way." Around them, the lobby seemed to shrink, the air heavier, every sound amplified. The hum of lights, the faint click of a camera adjusting focus. The man slowly reached into his coat, moving deliberately, narrating his actions without being asked. "I'm reaching for my wallet." As the leather creased open, neither of them yet understood how irreversible the next few minutes would be. One believed he was exercising authority. The other already knew this moment would end in court. The moment in the lobby seemed frozen, but the story did not begin there. It started decades earlier, long before a uniform and a badge decided who belonged and who did not. The man standing with his wallet half open was named Daniel H. Whitaker. At 46, his posture carried the quiet weight of someone used to being listened to, even when he spoke softly. He had grown up on the south side of Cleveland, the son of a postal worker and a public school librarian. Their apartment was small, their rules strict. Education was non-negotiable, respect was expected. Silence was often safer than argument. Daniel learned early how to read rooms before speaking. Which teachers listened, which did not. Which police cars slowed down too long when he walked home from the library at night. He watched his father stopped twice in one summer for a broken taillight that was never broken. He watched his mother keep her hands on the steering wheel whenever blue lights appeared behind them. He carried those memories through college, then law school, where he graduated at the top of his class. He clerked for a federal judge known for constitutional rigor, the kind who demanded every warrant be airtight, every detention justified. Daniel absorbed that discipline. He believed in the system not blindly, but insistently. He believed it could be forced to work correctly if the law was applied without fear or favoritism. By 38, he was appointed federal chief magistrate judge for his district. It was not ceremonial. He reviewed arrest warrants in the middle of the night. He ruled on probable cause affidavits before sunrise. He rejected sloppy police work without apology. He approved lawful searches when standards were met. His signature determined who would be arrested, who would be released, who would wait in a cell, and who would go home. He was known for one phrase repeated often from the bench: "Authority does not excuse ignorance of the Constitution." Officers remembered it. Prosecutors warned rookies about it. Some resented him quietly. Others respected him deeply. Daniel did not care which. He cared that the law was followed. The building he was entering that evening was not symbolic to him. It was simply home. A quiet place close to the courthouse. No security detail, no reserved parking. He preferred it that way. The officer who stopped him came from a different story. Officer Mark Reynolds had been on the force for 9 years, 34 years old, solid evaluations, no major commendations, no suspensions, the kind of officer supervisors described as reliable. He followed procedure. He answered calls quickly. He did not hesitate. Reynolds grew up in a small town where nearly everyone looked like him. His father was a corrections officer. Dinner table conversations often centered on inmates who lied suspects, who resisted situations that turned dangerous without warning. The lesson was always the same. Control first, questions later. At the academy, Reynolds learned policy, but he absorbed culture. Veteran officers taught him which neighborhoods required extra caution, which people talked too much, which ones tested authority. None of it was written down. All of it was passed along as survival knowledge. He had responded to dozens of suspicious person calls. Most ended with nothing. Some ended with arrests. Each time the report looked the same. Subject questioned. No crime found. Cleared. It never felt wrong to him. Someone called. He checked. That was the job. What Reynolds had not examined was how those calls were framed. How often suspicious meant unfamiliar. How often unfamiliar meant black. He told himself he treated everyone the same. He believed it. Belief made it easier. That evening, dispatch had been brief. Caller reports unknown male entering building. Does not recognize him. Reynolds heard the word unknown and translated it instantly to potential threat. When he arrived, he saw a black man unlocking a door to a federal building after business hours. In his mind, the pieces aligned. What Reynolds did not see was a judge who had signed his department's warrants. He saw a situation that challenged his authority in public under cameras with a man who spoke calmly and asked legal questions. That kind of calm unsettled him. In his experience, people who asked questions were testing limits. The past followed them both into the lobby. Daniel's lifetime of measured restraint. Reynolds's years of unchallenged assumptions. Neither spoke about it. Neither needed to. It sat between them like an unspoken third presence. When Daniel asked if he was being detained, it was not defiance. It was muscle memory. A legal reflex sharpened over decades. When Reynolds bristled at the question, it was not malice in his mind. It was instinct. An instinct trained to see control slipping. Two histories collided under fluorescent lights with cameras watching, and a misunderstanding already hardening into something else. What happened next would not be an accident. It would be the inevitable outcome of paths that had been converging for years. The lobby no longer felt empty. It only looked that way. The cameras were still blinking. The officer's radio crackled softly at his shoulder. Outside the glass doors, two people slowed their pace. Curiosity tugged by the tension visible even through tinted glass. Daniel held his wallet open now. His driver's license rested between his fingers, face up, ready to be seen. He did not step forward. He did not extend his arm. He waited. Officer Reynolds noticed the restraint and misread it as hesitation. "Let me see it," Reynolds said. Daniel nodded once and raised the license to chest level. "Here it is." Before Reynolds could take it, Daniel added quietly, "I want to be clear that I am complying under protest. I am not consenting to any unlawful detention." The officer took the card and studied it longer than necessary. Daniel H. Whitaker. Address listed inside the building. The photo matched the man standing in front of him. Reynolds felt a flicker of doubt quickly smothered. Addresses could be faked. IDs could be borrowed. He had been taught not to let details soften caution. "You got anything else that proves you belong here?" Reynolds asked. Daniel gestured gently with his free hand toward the door. "The key you watched me use. My lease is on file with building management. If you'd like, we can call them." Reynolds shook his head. "Not yet." He took a step back, angling his body so the camera caught both of them clearly. "I'm going to need you to stay right here while I verify this information." At that moment, the elevator doors slid open. A woman in business attire stepped out, paused, and immediately sensed something was wrong. Her eyes moved from the officer to Daniel, then to the hand near the officer's belt. She hesitated, then quietly pulled out her phone. Another man entered the lobby from outside, slowed, and leaned against a column pretending to check messages, while his camera lens angled just enough to record. The crowd was not large, but it was present, and Reynolds felt it. "Am I being detained?" Daniel asked again, his tone unchanged. "Or am I free to go upstairs?" Reynolds exhaled through his nose. "Right now you're being detained for investigation." Daniel nodded slightly as if filing the words away. "On what specific grounds?" The question landed differently this time. It was not loud. It was not confrontational. It was precise. Reynolds felt heat rise in his neck. "Suspicious activity. We received a call." "Suspicious?" how Daniel asked. "Entering my own building with a key is not a crime." Reynolds turned his head briefly toward the woman with the phone, then back to Daniel. His voice dropped. "You keep pushing like this, you're going to make this harder on yourself." The woman near the elevator spoke not loudly but clearly. "Officer, he hasn't done anything. He lives here." Reynolds shot her a look. "Ma'am, stay out of this." The phone stayed up. The silence thickened. Daniel stood perfectly still, hands visible, posture relaxed but immovable. He understood the shift that had just occurred. This was no longer about verifying information. This was about control in front of witnesses. Reynolds felt it too. The calm man was not backing down. The questions were exposing cracks. The crowd was watching. In his mind, stepping away now would look like failure. So he chose escalation, not because it was necessary, but because retreat felt impossible. "I'm going to run your information," Reynolds said. "You're not going anywhere until I'm satisfied." Daniel met his eyes. "Take all the time you need, officer. But understand that everything happening right now is being recorded." The words were not a threat. They were a statement of fact. And they settled over the lobby like a weight pressing the moment toward a point of no return. The decision was made before the words were spoken. It showed first in the way Officer Reynolds shifted his weight, in the subtle change of posture that signaled action rather than conversation. His hand moved slow but deliberate toward the cuffs on his belt. "Sir, turn around and place your hands behind your back." The sentence dropped into the lobby with a dull finality. For a brief moment, no one moved. The fluorescent lights hummed overhead. Somewhere above them, a door closed softly. Daniel did not react right away. He looked at Reynolds, then briefly at the phones raised around them, their lenses unblinking. "On what basis?" Daniel asked quietly. Reynolds did not answer. He stepped forward, closing the distance. "You are being detained for failure to cooperate with a lawful investigation." That was the moment the air changed. The woman near the elevator inhaled sharply. Someone muttered, "This is not right." Daniel exhaled, once slow and controlled. He understood exactly what was happening. He also understood the danger of resisting it. "I am not resisting," Daniel said, turning his body inch by inch. "I am complying under protest." Time seemed to stretch. Every movement slowed. The metal cuffs came free with a soft click. Reynolds guided Daniel's arms back, his grip firm, almost too firm. The cold steel closed around Daniel's wrists. The sound echoed louder than it should have, a sharp metallic snap that cut through the quiet. Daniel's jaw tightened just for a second. The pressure bit into his skin, not enough to injure, but enough to remind him how quickly dignity could be stripped away. He stared straight ahead, refusing to give the crowd the satisfaction of visible emotion. Phones rose higher. One voice broke through. "He didn't do anything." Reynolds did not look at the speaker. His focus narrowed, vision tunneled, training overriding doubt. He guided Daniel toward the security desk, each step measured, rehearsed, irreversible. As they walked, Daniel caught his reflection in the dark glass of the building directory. A black man in handcuffs, flanked by a uniformed officer frozen in a frame that would soon exist far beyond this lobby. He noted the time on the wall clock without thinking. Evidence mattered. The patrol car waited outside, engine idling. Reynolds opened the back door. Daniel stepped in without resistance. The seat was hard plastic, faintly sticky, carrying the stale smell of disinfectant and old coffee. The door closed with a hollow thud. Inside the car, silence pressed in. Reynolds sat in the driver's seat, hands resting on the wheel, not moving. His radio crackled again, then went quiet. For the first time since the encounter began, uncertainty crept in. It showed in the way his fingers tightened, then loosened. Daniel stared straight ahead through the metal grate, mind already working. He replayed the exchange word by word, cataloging statements, actions, timing. Probable cause. reasonable suspicion, unlawful detention. He knew exactly how this would be framed. He knew exactly where it would end. The car pulled away from the curb. The building receded in the side mirror cameras, still watching witnesses, still filming. What had started as a question in a lobby had crossed a line. There would be no quiet resolution now. Only consequences unfolding one step at a time. The processing room was smaller than Daniel expected. Beige walls, a metal desk scarred with old scratches, a computer monitor humming softly in the corner. The cuffs were removed, but the weight of them still seemed to linger on his wrists, an imprint that was not physical. Officer Reynolds stood near the door, arms crossed, posture stiff. He avoided Daniel's eyes. A younger officer typed information into the system, pausing once to look up at Daniel's face, then back down at the screen. "Name," the officer said. Daniel answered evenly. "Daniel Harrison Whitaker." The typing stopped for half a beat. The officer frowned at the monitor. He glanced at Reynolds. "Sir, can you repeat that?" Daniel did. The name landed differently this time. The officer's fingers resumed typing, slower now, more careful. The system chimed softly as records populated. His brow furrowed deeper with each line that appeared. Reynolds shifted his weight. "What is it?" he asked. The younger officer did not answer right away. He turned the screen slightly, reading again, as if hoping he had misread it. He stood and walked toward the adjoining office without a word. The room fell silent. Daniel waited. He had spent years in courtrooms recognizing this exact pause. The moment before realization. The door opened again, this time with purpose. A lieutenant entered, followed closely by the younger officer. The lieutenant's eyes went straight to Daniel, then to Reynolds, then back to Daniel. "Judge Whitaker," the lieutenant said carefully. Reynolds froze. The word hung in the air, heavy, unmistakable. He turned slowly. "Judge." Daniel met his gaze for the first time since entering the room. "Yes." The lieutenant swallowed. "Federal Chief Magistrate Judge District Court." He straightened unconsciously, years of instinct taking over. "Sir, there appears to have been a misunderstanding." Reynolds's face drained of color. His mouth opened, then closed. The confidence that had carried him through the lobby evaporated, replaced by something raw and exposed. He took a step back without realizing it. "You stopped a federal judge," the lieutenant said, his voice low now. "You detained him without charge." Reynolds shook his head once, as if that might undo what had already happened. "I didn't know." He didn't say. Daniel's voice was calm, but it cut cleanly. "I asked if I was being detained. I asked for the legal basis. You chose not to ask who I was." The lieutenant closed his eyes briefly. He exhaled, slow and controlled. "Judge Whitaker, I apologize. This should not have happened." Daniel nodded slightly. "Apologies are noted. Documentation is required." Reynolds stared at the floor. The room felt smaller, the walls closer. He saw it now. The cameras, the witnesses, the questions he had dismissed, the assumption he had never examined. Fear crept in, sharp and undeniable. The lieutenant turns to Reynolds. "Turn in your body camera. Do not write your report yet." Reynolds looked up, eyes wide. "Sir, now." As Reynolds unclipped the camera from his uniform, his hands trembled. He understood the shift that had occurred. Authority had reversed. The imbalance he had enforced minutes earlier had collapsed completely. Daniel stood. He adjusted his coat movements, precise, dignified. "I will be leaving now. My counsel will contact your department." The lieutenant stepped aside. "Yes, sir." As Daniel walked out of the room, the silence he left behind was heavier than any raised voice. The truth had arrived not loudly, but decisively, and nothing that followed would soften its impact. The video surfaced before sunrise. By 7:18 a.m., a 34-second clip from the building's security camera was circulating on social media. A black man unlocking a door. A uniformed officer stepping into frame. The pause. The body language. By noon, multiple angles had been stitched together. Phone footage from the lobby, audio from the officer's body camera. Each clip added context. Each frame stripped away excuses. "Federal judge detained while entering his own building" became the headline no one in the department wanted to read. By the end of the day, the footage had crossed 2 million views. Comment sections filled faster than moderators could keep up. Lawyers dissected the encounter frame by frame. Former officers weighed in. Civil rights advocates pointed to familiar patterns. The question repeated again and again. What was the crime? Daniel did not speak publicly. He did not need to. His actions did the talking. 48 hours later, a federal civil rights complaint was filed. It was precise. No rhetoric, no exaggeration. Unlawful detention without reasonable suspicion. Violation of Fourth Amendment protections. Abuse of authority under color of law. Failure to intervene. Failure to supervise. Each allegation supported by timestamps, transcripts, and video stills. The department announced an internal investigation that same afternoon. The statement was brief, standard language, matter taken seriously, full cooperation promised. Behind closed doors, the tone was different. Officer Reynolds was placed on administrative leave. His patrol vehicle was reassigned. His locker was sealed. Supervisors reviewed his prior stops. Patterns emerged. Stops that escalated unnecessarily. Complaints that had been dismissed as misunderstandings. Incidents that on their own looked minor. Together, they told a story. The city attorney watched the footage once, then again, then called an emergency meeting. "This is indefensible," he said. "There is no version of this where we win." Settlement talks began quietly and ended quickly. The number was substantial. Enough to make headlines. Enough to signal consequence. Daniel accepted without negotiation. He directed the funds to legal aid organizations and constitutional training programs for public defenders. Money was not the point. Precedent was. Officer Reynolds was terminated 3 weeks later. The termination letter cited violations of department policy, unlawful detention, and conduct unbecoming. His appeal lasted less than an hour. The footage played. No further questions were asked. The department announced mandatory retraining, new protocols for suspicious person calls, explicit language about bias, mandatory verification before detention. Press conferences were held. Promises were made. The cycle of accountability spun forward, at least for now. Daniel returned to the bench the following Monday. The courtroom rose when he entered. He acknowledged no special attention. The docket moved forward. Warrants were reviewed. Cases were heard. The law continued its slow, deliberate work. But the video did not disappear. It was shown in academies, in law schools, in community meetings. A quiet reminder of how quickly power could slip into abuse and how firmly it could be pulled back when light was applied. Justice had not been loud. It had been methodical. And for once, it had been visible. What happened in that lobby was not a misunderstanding. It was a textbook constitutional violation, clear in law long before it became clear on video. Under the Fourth Amendment, a police officer may not detain an individual without reasonable suspicion based on specific, articulable facts that criminal activity is afoot. Entering a building with a key does not qualify. Being unfamiliar to a caller does not qualify. Looking out of place does not qualify. Suspicion rooted in discomfort or assumption is not suspicion at all under the law. The moment Officer Reynolds ordered Daniel to stop, a seizure occurred. When he demanded identification without a lawful basis, the violation deepened. When he escalated to handcuffs without probable cause, the line was crossed completely. Courts have been explicit for decades. Compliance under protest does not create suspicion. Asking legal questions is not obstruction. Calm assertion of rights is not resistance. Psychologically, the incident followed a familiar pattern. Implicit bias narrowed perception. Once the officer accepted the idea that Daniel did not belong, every subsequent fact was filtered to support that belief. Evidence that contradicted the assumption was dismissed. Questions were perceived as threats. Calm was misread as defiance. This is how bias operates, quietly, efficiently, until it is interrupted. For the public, there are lessons that matter beyond this case. If you are stopped, keep your hands visible. Speak clearly. Move slowly. State that you are complying under protest if you believe the stop is unlawful. Ask whether you are being detained or free to leave. If detained, ask on what grounds. Do not argue on the street. Document when possible. Witnesses and video change outcomes. For officers, the lesson is sharper. Authority does not grant immunity from constitutional standards. Training is not a shield if it reinforces unchecked assumptions. The law demands justification, not instinct. Every stop is a decision point. Every escalation is a choice. Daniel's case ended with accountability because he had knowledge, position, and evidence. Most people do not. That imbalance is the real issue. Justice should not depend on who you are once your rights are violated. It should depend on what the law requires. This story is not about a judge. It is about a moment when power met restraint and restraint won. The question is not whether this can happen again. It already does. The question is whether it will be seen, recorded, challenged, and corrected. If this made you uncomfortable, it should have. If it made you angry, that is reasonable. The law exists to protect dignity as much as liberty. When it is enforced selectively, it fails both. What do you think should change to prevent this from happening to someone without a title, without cameras, without leverage? That answer matters more than any verdict.